Defense lawyers. What is it like to defend a client who has confessed to you that they're guilty of a violent crime? Do you still genuinely go out of your way to defend them? I'm a defense lawyer. 95% of clients are factually guilty. No, it makes absolutely zero difference to our motivation. It's a huge misunderstanding that the justice system determines guilt and innocence. It doesn't. It determines whether the state has enough evidence to lock a human in a cage against their will. So a client actually being guilty has nothing to do with that question. Moreover, the vast majority, 90+%, even if you're a very aggressive attorney, end in a plea. The issue is usually that your client is guilty of something for which they have sufficient evidence, but the state has overcharged. You find a reasonable balance based on the strength of the state's evidence. A trial is a broken negotiation, and typically only happens if one side is being completely unreasonable, is dumb, or has nothing to lose. Edit. Let me address the biggest topic of conversation in the comments, overcharging. Couple points. Yes, it happens all the time. All the time. Especially in lower income communities. Police and prosecutors start from the very highest thing they could possibly charge. Here's what doesn't happen, which has been brought up a lot in the comments. Guy steals a pack of gum. State charges him with murder. We plead to robbery. Bargaining in a legal case isn't like haggling for a car. There's not a high ball and a low ball and we land in the middle. That's because the defense is supposed to see the evidence, so we know what the reasonable charge would be. It's more like this. Guy steals a pack of gum. State charges robbery, battery, assault, and resisting arrest because they allege a scuffle happened during the theft. I look at it and say, okay, the state's got great evidence of the theft and really weak evidence of the scuffle and medium evidence for resisting arrest. So we plead a theft, screw off with the robbery, battery, and assault, and we haggle over the resisting. If I think maybe they get the robbery, then I advise my client to eat the resisting because it really doesn't add to much, and the penalty for robbery is 10 years. If I feel confident that they're screwed on robbery, we hold strong and only plead a theft. So basically, if you have a good attorney, we just bash through the overcharging. Does it move the needle? Yes. Do people cop to charges a bit higher than they should because of the threat of the overcharged crime? Yes. But are people pleading out to absurd things they didn't do because the state is waving bogus murder charges over their heads? No. Good attorneys do not let that happen. Story 2. I'm a defense lawyer as well. TLDR, the criminal justice system is so oppressive, I don't care if a guilty client or two gets off scot-free. On the whole, it benefits society. There are two kinds of defense lawyers. The ones that live for getting an innocent client off, and those that live for getting a guilty client off. I am probably the latter kind. At the end of the day, most defense attorneys, especially those in more rural areas, believe the sentencing and fines for most offenses are outrageous, and they perpetuate a system of oppression of the disenfranchised. Marijuana possession, $600, 2 days jail, and substance abuse classes. Operating while intoxicated, whether sitting in a car with the engine running because it's cold or legit drunk driving, easily $2,000-ish, along with a license suspension, increased insurance costs, and 2 days jail. Often sentences come with 1 or 2 years of probation, which drags on with 90 to 180 days in jail if they don't do well enough. Story 3. What I've gleaned from reading lawyer blogs, it's about defending people's right to a fair trial. Even if someone is totally guilty, prosecutors still overreach and overcharge the perp with plenty of other things they can't prove or haven't even done. The power of the state is incredible, and compared to you, almost unlimited. Defense lawyers have to help make sure that you know your rights, and that your rights are defended, or that you at least get something out of giving up some of those rights. Keep in mind the state will bring hell on you whether you're innocent or guilty, and ideally defense lawyers will defend everyone's rights equally. One article I read that really stuck with me is from Chasing Truth, Catching Hell. Dear Norm, how do you actually defend those people? He discusses someone accused of a heinous crime with no defense whatsoever, and answers the question, how do you defend them? What actual steps do you take? Some excerpts. First, I mentally prepare myself for the very real possibility that I will be stuck taking this case to trial. This defendant is the worst of the worst, Mr. or Mrs. District Attorney may say, and he deserves nothing short of a life sentence. This may be true, but it does not relieve me of my ethical obligation to safeguard my client's rights unless he's offered something in exchange for giving them up. Clients hurt themselves most when they feel out of control over their legal situation. Such clients feel railroaded and see their public defender as just another piece of the machine that is pushing them towards a certain outcome. When this happens, the client resists the public defender's advice just for the sake of resisting the process as a whole. I remind the client that the decision to go to trial and the decision to testify are his and his alone. But I also remind him that he has the power to set a more realistic goal for himself. Finally, I document every decision that I make in the case, as well as the reasons for it. My client will be convicted. An appellate lawyer will be running a fine-tooth comb through the record of the trial, and if I screw something up so badly that my representation was constitutionally defective, then appellate counsel can and should argue this to the appellate court. If I can't defend myself, my client's next lawyer will argue that I didn't defend my client either. I highly recommend reading the entire article. This OP came in with an article as reference and everything. You know what? This may be one of the few times I'm like, okay, so you're not a lawyer, but your post? Pretty helpful. I also have no idea what the word appellate means. I don't know if I'm saying it right. Story 4. I had a lawyer. I confessed to my grand theft auto to my lawyer, but I was with 4 others who did it. We spoke of plea options, but he wanted to wait and grant continuances to see how the other cases were billed. I ended up getting off like a year and a half later. One guy pled guilty and got safe house. Another got probation, and 2 of us got off completely. I never had to speak in court other than to ask for continuances when he was unable to make it. Then it just got dropped eventually. I was the only one who lawyered up immediately. The guy who got safe house fell for the, "We have you on video," with no attorney present. There ended up being no video. If everyone had lawyered up, we probably wouldn't have gotten any time because we took a car for a joyride that had the keys in it, then ditched it somewhere else. Some fellow college students saw us in the vehicle, and some guy stole some other guy's girlfriend, and that guy went to the cops with information since we were blabbermouths, and told people we stole it. That is what got us in questioning. This was like 15 years ago when I was in college. Story 5. So I've commented a bunch on this thread, but wanted to chime in with an actual answer to the question. 1. What's it like? The same as it is for any other case, regardless of whether there's a confession. It means I now count amongst my acquaintances one more still alleged assaulter, wife-beater, robber, or drug dealer. If all you knew about me was the people I knew, you'd think I kept pretty crap company. How I feel doesn't matter. What I do does, and the approach to somebody who tells you they did it is frankly easier when they tell you they didn't and swear their innocence 50 ways to Sunday. Everybody has the right to plead not guilty. So for me, anytime I approach a case, I start from the top. Was the investigation constitutionally satisfactory? That means, are there issues with the traffic stop? Defects in a search warrant? Issues with the way a confession was elicited if there was a confession? Thank Christ for clients who know how to shut the hell up, by the way. Was the lineup correctly done? Amongst any number of other questions. Because investigatory protections aren't just technicalities for the sake of a technicality. I had a jurisprudence professor who hated the term technically, and I agree with him. Every technical or procedural rule exists for a substantive reason. If a client is guilty of sin of, say, a drug possession, and there's a gun in the car and he has a violent felony, but their car never ever should have been stopped, the client doesn't deserve a guilty finding because their rights were violated. If we didn't believe that, the entire rule of law system we cherish would fall to pieces. Next question. Do the prosecutor's facts match the charges? Sometimes punching somebody in the nose is an attempted murder. Sometimes it's just an assault and battery. Sometimes a phone snatching is a robbery. Sometimes it's just interference with a 911 call. Note, not my burden. I have no obligations whatsoever in a criminal trial. One of my favorite judges, when beginning voir dire, asks the jury if they understand that me and my client can sit at counsel table and say literally nothing the entire trial. No cross, no evidence. And if the state's facts do not match every element of the offense beyond a reasonable doubt, they must find my client not guilty. Whether my client has said diddly squat to me is, at this stage, irrelevant. All that matters is that they can prove their case using their evidence, obviously absent any tampering by me or my client. If they can't, then I sleep at night, even if my guy is guilty of sin or whatever. It's not my job to prove him innocent, it's their job to prove him guilty. Next question, and this to me is the last, and unless my client maintains their total innocence, not the most important part of case prep. What evidence, if any, do I have or can I use to undermine their case? Note, not prove my client's innocence, undermine their case. Maybe that's evidence to attack the credibility of their witnesses. Maybe it's my client's testimony. Maybe my investigator has uncovered proof positive of innocence, and once I get my evidence, we figure out how to get it all in. 2. Do you still go out of your way to defend them? First things first, do I like my $200,000 bar license? Because if I don't go out of my way to run through all of the above steps in every case, I might as well send the pieces of my bar card back to my state licensing authority and find something else to do with my time. Second, defend is a malleable concept. As I said before, technical rules serve substantive purpose. If there's a suppression issue, I chase it. If there's a sufficiency issue, I chase it. Because not only is that the job, it's the interesting part of the job. If you've got evidence of 3 murders in your house and that's all they've got, and the search of your house was patently illegal, There's two conflicting sets of moral justice, and I think OP and I fall on different sides of that. The morally right outcome is either that the integrity of rule of law is preserved, or that a murderer goes away. But I don't think you can hold both moral views about the same case simultaneously. Note aside, I have immense respect for cops, and I've never met one worth the crap that would allow this factual scenario to ever happen. Realistically though, defend and win don't mean get guilty people found innocent. They mean get the best possible outcome that you and your client can agree on trying to get. Rarely that is yes a not guilty finding for an icky criminal. Mostly it's getting the least bad option out of a bad situation. Third, is it a problem even if I do? Frankly, I get more upset at some non-violent offenders than a lot of violent ones. DUIs make me upset. I don't care if people drink, but I care a lot if they get wasted and don't have the sense to stay put until they're good to drive. That's effectively thousands of pounds of missile you're putting into gear without sufficient means of controlling it. DUIs are a bit of a menace. People who steal and don't have poverty, drugs, or mental illness as an excuse really annoy me as well. No, I don't think a poor person doesn't deserve a PlayStation, and I mostly don't care about a big corporation's bottom line, but you don't get to take crap just because you want it and then act offended when you get called out. There are certain criminal frauds that I find quite offensive, and some drug dealers who drive men mad. Sorry, but why the hell are you dealing drugs laced with fent? I feel like this thread, more than most, I can tell who's answering the questions. Like every post from a lawyer really feels like it's from a lawyer. Just the way they talk, and also partly because they use words I don't know. It's definitely interesting to hear what the lawyer thinks is a more offensive crime. I agree with both of their points on the non-violent ones. Those can be a lot worse than violent ones. DUIs in particular, I'm fully with OP. Hate that. Story 6. Everyone deserves constitutional protections. It doesn't matter what you've done. The Constitution isn't pick or choose. Defense lawyers, at least public defenders in the US, focus on that a lot of the time. Child assaulters can be hard, but if you remember that the Constitution still applies, you can get through. It's a certain level of objective detachment. A defense lawyer makes sure the government isn't steamrolling you and is actually following procedure. Defense lawyers are a bulwark against government overreach. Or they should be if they're competent. Also, a lot of people who do violent crimes, I believe SCOTUS just held that pickpocketing is a violent crime for sentencing determination, so violent is a legal term that can vary wildly, to say the least, have screwed up lives. I know a guy who is severely schizophrenic who thought a woman was an angel robbing him, but it turns out he was mugging her with a gun and didn't realize it. He thought he was getting his money back from a thief. Public defenders usually try and focus on hooking people up with services and healing that they might not know about. Also, there are loads of women specifically in prison for, quote, violent crimes who are there because they were defending themselves against their abuser and got sentenced. I personally know a woman who'd been in jail for 20 years. This was for ending her abuser who went after her child one night. Centoya Brown is another great example. These stories aren't the exception. People who commit violent crimes are still people. Not everyone is a raving, heartless monster or Ted Bundy. Those are the exceptions, and even then, it's still not the hardest thing to defend if, at least in the US, you frame it not as letting someone guilty get off, because, surprise, most people do not just, quote, get off. I really hate when TV shows are like, he got off on a technicality. Is the Fourth Amendment a technicality? Is that really what you're saying right now? Story 7. You have to. That's the way an adversarial legal system works. Being charged with a felony is a long process. It can end quickly with a plea or drag on a trial for years. You're obligated to present your client the evidence and give them your legal counsel. If it's bad, you tell them it's bad and that they will lose at trial. Some clients still want their trial. If your client wants their trial, you go to trial. At this point approaching trial, some clients might have told you that they're guilty. You have to put it furthest from your mind because you're going to have to get up in front of a courtroom and do everything you possibly can convincing 12 people that your client is innocent. What I've observed in the more overwhelming cases, you try and beat the most extreme charges, negligent homicide or manslaughter instead of murder, etc., and you make the state earn every charge. You hold the police accountable to best practices and take them to task when they screw up. You put on every witness you could possibly think to help your client. You put your hands on your client's shoulder and you say, "Ladies and gentlemen, my client sits before you, an innocent man." And then you give a hell of a closing argument. You have to do everything possible to prove your client is innocent or the system doesn't work. If you don't do it for the guilty, sooner or later, the innocent will be affected too. I think this is what happened in New Orleans where I work. For decades, defense lawyers worked for the judge and not their clients. None of them ever fought for their clients. No one held the police accountable to doing a good job, and the courthouse revolved around convicting everyone brought before it, guilty or innocent. Of course, this mostly affected Black Americans because the system was created to replace slavery after the Civil War. It's called convict lease. Now, it is very hard to save innocent people from the system. You can't get the prosecutors to even look at the evidence until you force a trial, and that can take 2 years or longer. And when you get there, the judge is often arguing the case for the prosecution. Felonies carry extreme penalties, so you often find yourself advising an innocent client that their best chance might be taking felony time to avoid risking 30 or 40 years or even life. I've worked in this adversarial system for 5 years, and I don't believe it's the best way to do things. There are alternatives that can provide better outcomes for victims and the accused, innocent and guilty alike. Within the system we have, you have to ignore whether you think your client is actually guilty and fight for their innocence, no matter what. Story 8. I get this question a lot. First, I remind people that my function as a lawyer is materially different than judge or jury. It does not require me to assess guilt. If I know someone is guilty, it doesn't change my function. Please know that functional does not mean robotic or conscienceless. Second, I indicate that a court of justice is not a court of popular opinion or emotional retaliation. As a society, we have found boundaries appropriate for justice in terms of treatment and punishment under the law. Indeed, impartiality is a core concern for our judges and juries. As to the appropriate boundaries for justice mentioned above, we as a society have also agreed that all persons shall be treated equally under the law. Third, and aside from the core principles mentioned above, attorneys' licenses are often regulated by state boards. Among the regulations in nearly every state is the duty for an attorney to zealously advocate for their client. It's worth noting that many states also explicitly reference withdrawing from representation if an attorney has a material disagreement with their client that would impede their ability to represent them. Conclusively, we can see that our legal system is designed to benefit all equally, and that fairness and impartiality are core concerns on the sides of both adjudication and representation. It is the special role of criminal defense attorneys to honor the principles of law before their own. It's a duty above self thing, in honor of evolved and learned society. In fairness and with respect, the existence of your question is why lawyers must be regulated and why laws must be adjudicated by impartial persons. And one final sentiment: many persons charged with gross offenses believe themselves to be monsters or less worthy. Many of them have been victims themselves in transformation to what they've become. And while choice is always available, you might consider the original position model of ethics as to what person would ever choose to be so despised by society and plagued with behaviors of condemnation. Mercy is meaningful, and equal treatment is cognizant that truth and reality are contextual to our immediate existence. I hope you found my answer to be beneficial to your understanding. OP gave a great response, but the last sentence feels like a robot, right? I don't mean like an AI wrote this, but like, think of Big Hero 6. Like you can imagine Baymax saying, I hope you have found my answer to be beneficial to your understanding. Can't you? I don't mean to take away from OP's response, though. They really drove home what everyone else in the thread has been saying. The right to a fair trial means your defense has to fight for you. It really seems to boil down to just that. When your defense doesn't fight for you, the whole system falls apart. Although I think it can be argued that the system is already not, like, fully together. But hey, I'm not a lawyer. Anyway, thank you so much for watching. I hope you have a wonderful day or night wherever you are, and I will see you in the next one.